And the next case on the docket is Progressive Select Insurance Company versus Florida Hospital Medical Center. And case 2025-317. So whenever you're ready, you may begin. Good morning.
Good morning, Your Honors. May it please the Court. My name is Michael Clark, and I'm here today on behalf of Progressive Select in these consolidated appeals. The relief that we're requesting is that on de novo review that you reverse the final summary judgments that have been entered in, on behalf of the Florida Hospital Medical Center and remand for either entry of judgment in favor of Progressive or for the trial court to resolve the factual issue on the reasonableness of the charges of Florida Hospital Medical Center as presented. So briefly, these are two breach of contract actions for payment of no-fault benefits. As part of that, the standard of proof requires that the provider in this instance show that the service that they provided to the assigned or insured was in a gross amount that was presented that was reasonable. And in support of the plaintiff's motions, they produced two affidavits, one from Florida Hospital Medical Center.
So is it your main argument that you should be able to entitled to contest the reasonableness of these charges? Is that why summary judgment should not be entered?
Yes, Your Honor. Preliminarily, the argument was set up with challenging the sufficiency of the affidavits that supported the Florida Hospital Medical Center's motions for summary judgment.
But at least in the trial court's order, they said they're not preventing you from doing that. They just said you didn't do that. You didn't contest that. So how do you respond to that?
Well, I respond to that by saying this. In the record, not only is there evidence of the payments that were made by Progressive, and I want to be clear in stating this, I'm not saying that the amount of the reimbursement determines or is a de facto payment of a reasonable amount. I am saying that when it is uncontested fact that the usual and customary charges were those that were presented by the provider in this instance, under the statutory language, which existed in 2008, we're looking at two different things. We're looking at the fact-dependent analysis under 5.1a, which allows for the consideration of a number of different factors, including the usual and customary charges and payments accepted by the provider, the reimbursement levels in the community, and various federal and state and medical fee schedules applicable to automobile and other insurance coverages. So when the court's question is, where have you shown, if the burden shifts to you, that there is something in the fact-dependent methodology that you can use, because we're precluded by virtual, under the election standard of virtual, from using what is now called the schedule of maximum charges, by just saying, well, we paid 75% of the usual and customary charge that was presented. And it's in the record in two places. Both of the employees for Progressive who testified to the fact that they paid the usual and customary charge as presented at 75% of the hospital's usual and customary charges. And when you refer to that schedule of maximum charges as incorporated into the fact-dependent methodology, we know because of the Florida Supreme Court's decision in MRI Associates that those two methods are not mutually exclusive.
The hospital asked for more, correct?
The hospital asked for more than, yes.
Okay.
Asked for more than what would be the amount that would be considered a de facto reasonable.
So is there anything in any affidavits that were filed or anything in depositions that would show those amounts were not reasonable that they requested?
Well,
because I think that's where the trial court was at,
the trial court ended up in two different. There are no affidavits that are saying that an amount is unreasonable, because that's not what we need to do.
Okay.
They need to show that their amount is reasonable, not anything that the amount of the gross service charge is reasonable. That's what they need to do. We simply need to present an issue of fact and under the procedural posture of the case. And with the trial court talked about two things: jury instruction and the lack of corresponding oppositional evidence to create an issue of fact, and including whether or not a reasonable amount could ever be a range of figures. So what I would like to talk about is a roadmap to how we could get to not losing sight of the fact that I've already identified one place in the record where the deposition testimony of the Progressive's litigation adjusters showed that what would be an amount paid that fits within the fact-dependent method, but also the affidavit and this cost, what was employed by the plaintiff to show that the amount charged was reasonable was something called a cost-to-charge ratio. And essentially what that is, and the trial court talked about the sale of a vehicle when it was looking at this issue, and what it said was, you know, there's a price tag on it, and then is that amount reasonable? What would be somebody pay for it? And the expert that was presented on behalf of the plaintiff used this cost-to-charge ratio analysis. The cost is what something actually costs. So in looking at the record, there was one thing that stood out that is very relatable, and that was a service to Mr. Colon for a knee immobilizer. And this knee immobilizer had a gross charge, as presented by the hospital, of $236.01. So that would be something that Florida Hospital Medical Center would have to show that was a reasonable amount. And then under the reasonable expense mandate that's built into the statute, and under the policy language that's at issue, 80% of that amount is what would need to have been paid. Now, the plaintiff wants to take that amount, $236.01, and say the amount due is $188.80, excuse me. The defendant, and what was paid in this case, was 75%, that reduces to 177.00, then you take 85%, and that goes down to 144.60. So that was the actual reimbursement amount in this case. On page 1776 of the record, that's where the affidavit says that for that knee immobilizer and that constellation of charges for services for Mr. Colon, that Florida Hospital Medical Center had the second to lowest cost-charge ratio of providers in that geographical region. Again, these are usual and customary numbers. When you look at her deposition, and this is at 5582 through 5590, she goes through the cost-charge ratio analysis. And what that does is it essentially takes the cost of the product, which in this instance was $77, that's for the knee immobilizer, and then she used something called a general markup, which was, again, in her affidavit and in the deposition testimony. So you take the gross charge presented, you reduce that by the cost, you divide that by the profit, and then you convert it in using this, the charge ratio to determine the markup. And in that instance, it yields a figure of $206.51. So what does that tell us? It tells us that their own expert on this record has somebody with a reason saying that a reasonable charge presented was $236.01, but using the methodology that she employed, it's a figure less than that, $206.51. So I'm swinging it back to what your question was about proof in the record and trying to make sense of what the court's order said.
Were you able to raise that dispute in the deposition?
It was discussed. It was discussed on how the calculation was performed.
Okay.
Yeah. So in any event, what the jury instruction says is whether a charge is reasonable, if you find the charge for a service or service is reasonable, you should award that amount as damages. So that would be if the jury determines that the $236.01, that gross service charge, then that is a reasonable amount. That's the plaintiff's burden of proof. You should award that. If you charge for a service or service is not reasonable, you should award an amount that the greater weight of the evidence shows is reasonable. And the court talked about it doesn't have to be a specific figure. It could be a range. So I can answer your question now very specifically, Your Honor. One, we now have, and we're not precluded from under this court's own opinion in Progressive Select versus Emergency Care Physicians, we're not precluded from using the schedule of maximum charges, and we have the evidence from the litigation adjusters who say this is the amount that we paid, this is why we paid it, there's no dispute that that's a usual and customary amount, and we also have evidence in the record that there are lower charges than the charges that were presented. So that goes both to the jury instruction, and it goes both to this idea that there could be a range of figures. So at a minimum, there's an issue of fact there. And it is difficult to get to because the analysis of the charge to cost ratio is grouped in such a fashion that she never, the affidavit never actually gives you a precise figure. You have to go through the calculations, which was done in the deposition. So if I had to hang my hat on a case that also answers that question, there's really two of them. And excuse me, Judge Harris, you, when you were on the circuit bench, were part of a case called State Farm versus World Health Wellness. And that was after this court's opinion in Progressive Select, after virtual, but before MRI Associates. And in that case, it was a case like this one, except the payment was not made at 75% of the usual and customary charge. It was made at 200% of the Medicare Part B fee schedule. And in that instance, there was, the reasoning of the court was, applying Progressive Select to the case, we conclude that the trial court erred, and State Farm should have been allowed to litigate the reasonableness of World Health's PIP charges, even though its fee schedule and its insurance policy failed to give notice of its election to the fee schedule. Period. According to Progressive Select, under these circumstances, State Farm was precluded from availing itself of the fee schedule limitation, but would still be able to contest the reasonableness of the charge. And that's all we're asking to do in this instance, which is to use those two pieces of evidence supporting fact that should permit us to allow the use of the fact-dependent methodology under 5A1 to contest the reasonableness of the charge. There's another very important case that it, again, applies sort of the reasoning from Progressive Select. Again, it's a third DCA case, American Mobile Health Services versus State Farm. And in that case, again, the payment was made at 200%, not the 75%, but it was made by the insurer, granted summary judgment. And what the court said there, in reversing, and it looked at the payment of the payment that was made by the insurer, and it quoted with and reliance on another case, and said that if the insurer elects to use the fee schedule limitation, that schedule operates as a hard cap on the charges a provider may recover. But if the insurer does not elect the fee schedule, the federal and state medical fee schedules become one factor to consider in determining whether a provider's charges are reasonable, although those schedules are not dispositive. Gets us back to simply because we are not allowed to use the de facto cap of the maximum charge limitation, we can still litigate the reasonableness of that charge under the fact-dependent methodology. And one of those things is state fee schedules, and such as the PIP statute, and the idea of the usual and customary charge, which is not at issue here. Everybody agrees that this is what was been presented by Florida Hospital Medical Center as their usual and customary charge. Now, I am sure that the Appellee's Counsel is going to say, well, in American Health, there was an affidavit from Dr. Dower, who was someone who said that Medicare Part B that 200% was reasonable, and that would be distinguishable. But when you look at the idea that a layperson can testify to the reasonableness of a medical expense, the same principle should apply here. The idea that a litigation adjuster who performs a mathematical calculation under this state fee schedule applicable to automobile insurance, there should be no difference. It should be allowed to establish what
Mr.
a
Clark,
reasonable
you're in your
charge
rebuttal
is.
time, just
Right.
to let you know.
I thank you, Your Honors.
May it please the court.
Morning.
My name is Doug Stein, and I represent the Appalachia Florida Hospital Medical Center. Before I address the substance of Progressive's argument, it's important to emphasize what this case is not about. The issue in this case is not whether the amount paid by Progressive is reasonable. Rather, in accord with the requirements of subsection 736.5 of the PIP statute, the only issue in this case is whether the amount charged by Florida Hospital is reasonable. There was some mention regarding the standard of review. Certainly the standard of review on reviewing a summary judgment is de novo, but before even getting to that issue, Progressive has raised issues regarding the sufficiency of the affidavits that Florida Hospital presented in this case. The issues of whether those affidavits were sufficient, that standard review is the abuse of discretion of the trial court. And as I'll discuss, that the trial court was absolutely in its discretion to review both of those affidavits, and both of those affidavits satisfy Florida Hospital's burden on summary judgment, and the trial court correctly entered summary judgment in Florida Hospital's favor. So there are two basic methods to oppose a motion for summary judgment. First, the non-movement can attempt to demonstrate that the movement's evidence is insufficient. Or secondly, the non-movement can present its own evidence and try to convince a court that the evidence it presented presents a jury, an issue for the jury to decide. Progressive has attempted both of those methods in this case, and both fail. So first, Florida Hospital's affidavits in this case are sufficient. Are evidence, I should say, not just affidavits. It presented two affidavits, one of its vice president, one of its expert, and two depositions of those same people. Progressive filed no evidence whatsoever in this case about the reasonableness of the charge. There is an affidavit from its litigation adjuster who did testify. The way that we calculated what to pay in this case is we just took the number out of the fee schedules. The transcripts that Florida Hospital submitted satisfy its burden on summary judgment. Firstly, the affidavit of its vice president. He testified that the charges are reasonable, and he point blank testified that he has personal knowledge of those matters. Not to mention the fact that the Florida Supreme Court has held that an officer of a corporation is presumed to have knowledge, and there is no requirement for that affiant to attest as to where that knowledge was gained from. It is assumed that that officer has knowledge. He attested and testified at his deposition about the factors that were used to determine what amount was to be charged by Florida Hospital, and that amount was reasonable. The second witness that was presented by Progressive was its expert, and we all have a problem pronouncing her name, so I'm just going to refer to her as the expert witness. The argument that was presented by Progressive in regard to the expert was a Daubert argument, and but we only need to consider her testimony, her opinion, if this court determines that the vice president's testimony is insufficient, because even as opposing counsel has stated, that the the testimony of reasonableness of a medical charge by a medical provider of its own medical charge is sufficient to satisfy the burden on summary judgment. So again, only if the affidavit of the vice president is struck or that the order not striking it is overruled by this court, we even need to go to the expert's affidavit. Her affidavit in itself is sufficient. She had 50 years of experience working in the billing department of hospitals and companies that set rates for medical providers. She's been qualified as an expert by courts approximately 120 times, and her opinion clearly satisfies Daubert. Daubert requires that the opinion be based on sufficient data and the product of a reliable method that was properly applied. She used the charge data provided by various hospitals in the geographic area. This data provided by those hospitals to the Center for Medicare and Medicaid Services, CMS, and applied the cost to charge ratio, which is a universally recognized financial metric which compares a hospital's expenses to its charges. It represents how much it costs a provider to render a service or a piece of equipment based on the cost report filed with the federal government. It's regularly used by Medicare and the U.S. Labor Department to calculate certain compensation rates. And she obtained her data from 5 local hospitals and compared Florida hospitals' cost-to-charge ratio and determined that it fell right in the middle, and therefore the charge was reasonable. Progressive, in its brief, raised various arguments as to why it didn't think that that method was sufficient. Number one, that she didn't compare the actual charges. But the actual charges, the raw data of the charge itself, that's irrelevant to determine whether the charge is reasonable, because you can have a $1,000 charge that may not be unreasonable if it costs $950 to provide that service, but a $100 charge may be unreasonable if it only costs $10 to provide that service. So it's the cost to the charge ratio that is important. The expert, she correlated every one of those cost to charges with the particular service that was provided, the CPT code. They argued that her opinion was insufficient because she didn't use the fact-dependent methodology in the PIP statute. She didn't have to use the fact-dependent methodology. The statute itself says those factors may, not shall, but may be considered. And it also states that any other information relevant to the reasonableness of the reimbursement may be considered. So those 2 affidavits were sufficient. The trial court was clearly within its discretion to consider those 2 affidavits, and they satisfy Florida Hospital's burden on summary judgment. But Progressive also used the second method of opposing a motion for summary judgment, where it claims that what it did creates an issue for a jury. But what it did has nothing to do with the reasonableness of the charge. The only evidence that Progressive presented in this case was that it relied on the amount stated in the fee schedule to determine how much it was going to pay Florida Hospital.
Did it pay the maximum amount of that?
I'm sorry, Judge?
Did it pay the maximum amount of the fee schedule?
I believe it did, which was
Okay.
75%, 80% of 75%.
So is that in of itself enough to raise a factual issue as to reasonableness? I think that's their argument, correct?
It is their argument, and that argument fails because, no, what the fee schedule represents, if an insurer elects to use it, what it represents is a maximum amount that it has to pay. The legislature put that in the statute. It takes the question of reasonableness totally out of the picture. Reasonableness is no longer an issue when an insurance company elects in its policy to use the fee schedules. It doesn't matter whether the charge is reasonable because they elected to use it. When they elect or when they don't elect to use it, now reasonableness comes in. All the fee schedule represents is the maximum amount it has to pay if it elected to do so. It is not a list of charges that would otherwise be the maximum reasonable amount that a hospital can pay. And it's certainly, as counsel stated, that the There is a range of charges that can be reasonableness. $100 can be reasonableness, well, 101 be reasonable, 101 may be reasonable also, whatever that range is. So it's possible that the number that's stated in the fee schedule could be a reasonable charge if the hospital did charge that amount. But simply because that may be the case does not mean that the amount charged by the hospital, which may be greater, is unreasonable. It could also be reasonable. Now, counsel cited two cases. One was a circuit court case. Honestly, I just went through the briefs. I don't see that case cited in the briefs, but I may be mistaken, but I don't see it in the table of authorities. I don't recall that circuit court case. But the American Mobile case, which he cites, which is out of the 3rd District, clearly is something they relied on heavily in the briefs, completely distinguishable from this case. That was a trial, there was a jury, and Progressive presented Dr. Dower, who is an expert, who testified that the amount stated in the fee schedule was the maximum reasonable amount. That was evidence that the amount in the fee schedule was the maximum amount that could be charged, like Your Honor asked a minute ago. That didn't happen in this case. There is no Dr. Dower in this case. There is no evidence whatsoever that the amount stated in the fee schedule is the maximum amount that could be a reasonable charge. And that's what this case is entirely about. There is no evidence of that whatsoever. Your Honors, lastly, it wasn't addressed. He ran out of time, but I do want to address it because it is in the briefs, and it's the issue that I hate to bring up most, and that is in the event that Your Honors completely disagree with me and are going to reverse the trial court, Progressive has stated they're entitled to a judgment in their favor, and as opposed to just sending it back down for further proceedings. Not in this case, Judge. Again, Progressive presented no evidence. They have not shown at all that Florida Hospital is unable to present evidence which will create an issue for a jury. It is only shown, if you rule that way, in the unlikely, hopefully unlikely event you rule that way, it is only shown that Florida Hospital didn't sustain its burden on summary judgment. So if you do reverse this case, it should be sent back for further proceedings. More evidence can be presented. We move on from that point. But let me emphasize, Judge, that the affidavits were sufficient. Florida Hospital sustained its burden on summary judgment, and the judgment entered by the trial court should be affirmed. And unless there are any further questions, I'll rely on my brief for the rest.
Thank you.
Thank you.
Mr. Clark, you have just shy of 5 minutes.
Thank you, Your Honor. And I apologize to both the court and to Mr. Stein. In preparation for the oral argument and finding out the panel, I may have pulled the case with Judge Harris. And if it was not cited, that is my mistake. And I accept responsibility for that.
Thank you for your candor.
I have one point to make, and it goes with exactly what Your Honor said, Judge Boatwright. The idea here is there is a controlling case from the Florida Supreme Court, MRI Associates versus State Farm Mutual, where they answered a certified question saying that whether an insurer would be precluded to contest reasonableness based upon a payment made under the schedule of maximum charges if they also use separate statutory factors for determining the reasonableness of the charges, and they answered that in the negative. And there are two important things to be drawn from that case. The schedule of maximum charges sets a ceiling on what the maximum charge would be. If this progressive policy form had the correct election, we wouldn't be here because we paid according to the schedule of maximum charges. And the second thing that is important to be drawn from that case is that the fact-dependent methodology and the schedule of maximum charges are not mutually exclusive. That's specifically commented on by the Florida Supreme Court. And the point of what I'm making here is saying that we have just heard that the affidavits, the depositions, and the testimony of the both the litigation specialists as well as the expert show that the fact-dependent methodology factors were considered by Progressive in making its payment, which would be the usual and customary charge of the Florida Hospital Medical Center, as well as the automobile, as they say it, reimbursement levels and computing, and various federal and state medical fee schedules applicable to the automobile and other insurance coverages, which would be 5A1. And it also shows that we have you're not, simply because the ceiling is there, does not preclude you from using the other evidence of reasonableness, and that's where we created the issue of fact. Because the trial court's focus on the lack of an opposing affidavit is not discussed and or pinpointed down by MRI Associates or any of this court's precedent. That is always the fact is that you can always consider the evidence in the record in the manner that we've asked this court to do, which is showing what the usual and customary charge was and taking that portion of the maximum fee schedule and putting it back into the fact-dependent methodology, and that creates an issue of fact. Thank you, Your Honors.
Thank you, counsel. Thank you for your arguments, and safe travels back to Tampa and Coral Gables. We're in recess.